What's up, everybody, and welcome back into another video here on Sarah Boone. We have our first hearing with a privately retained counsel for Sarah Boone. We know he's asking for a motion to continue. He's asking for a bunch of other things in this hearing, and he also reveals specifically what their defense is going to be, what they need to produce that defense, whether or not he thinks it's going to happen before their October trial date. And we also see a bit of a different disposition from Sarah Boone herself. How does she feel about this case? Has that changed? We're going to find out as we watch this entire hearing together today. So we are starting basically from the beginning of this hearing before anything happens between the lawyers and the judges, because I want everybody to know exactly how Sarah Boone looked when she walked in the courtroom. And this is not, we're going to talk about her makeup or zoom in on her fly being up or down or anything like that. This is just specifically somebody who we've seen their demeanor throughout this entire trial be a certain way. Feels like it's unfair. The world is against her. Nobody cares about her. She's alone. But now maybe she feels like she finally has someone on her side, finally someone to help her and speak for her and represent her effectively, which is her right. And she didn't feel like anybody else could do the job. But now she feels like Mr. Owens, the person she has hired, can do the job. So we're going to take a look here at the very beginning of the hearing as we see what her demeanor is as she enters the courtroom. She's just about to sit down. Make sure you guys hit the like button if you have not already, and make sure you subscribe to our page. Let's take a look at Sarah Boone. Smiles, more smiles and giggles, looking at people in the crowd, giving faces, laughing. And then she looks at somebody across the courtroom and gives kind of like a, ugh, look at them. Ugh, they're here. Ugh, it's him. I don't know if it's the judge. I don't know if it's the prosecutor. I don't know if it's the bailiff. I don't know who it is. But very, very clearly different demeanor and reactions from Sarah Boone. And this to me seems like somebody who's confident. This to me seems like somebody who feels like maybe the tide is turning in her case. Maybe she wants a continuance and thinks she's going to win this hearing. I don't know. But let's get into the actual arguments that were made today in front of Judge Kranick. More smiles, more giggles. She knows the cameras are there too, which is another, I don't know why they have to zoom in so close to her face, but she knows the cameras are there. She's mentioned them multiple times in her letters and in her arguments in open court. So it's not like she thinks people aren't going to see this. She knows they're going to see this. Does she have fans in the stands? I don't know. Is it her friend there, family member? I don't know.
I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning, pleasure. Ms. Boone, good morning. Could you please state your, raise your hand now first and go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone.
So Friday, August 30th, they were able to view the evidence in Pinellas County Jail with Sarah Boone. Now, that's good. That's important for her rights. That's important because the deadline was today, and it's important because they didn't delay it, right? But was her lawyer involved? Because he filed his notice of appearance on August 30th. He had spoken to her multiple times prior to that. I didn't hear Mr. Cacciatore mention whether or not her lawyer was there. And if her lawyer wasn't there, she got to watch, or she got to look through all the evidence. They're going to have to do it again with her lawyer.
So can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense that was filed.
So there's some mixed motions here, not mixed emotions, but mixed motions. Some filed by Sarah Boone when she was pro se, and some filed by Mr. Owens, her new attorney. And yes, she is in handcuffs, which I found to be interesting because, you know, a lot of times we can get our clients to not be handcuffed, especially if there's already been an order, but maybe because she has a lawyer now, the judge is saying, no, she can just be handcuffed. It's just easier. Logistically speaking, she doesn't need to write or carry notes in and out with her now that she has a lawyer. Kind of interesting here. Peter, what's your impression of our new attorney? I'll give that as I go, but generally speaking, he's very experienced. I don't think this phases him, and I don't think he was surprised. Now, usually attorneys can win motions to continue. We'll see if he does today, but as he continues to argue, it's just rolls right off his back, whether the judge agrees with him or does not agree with him.
14th. The next day, August 15th, JCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist.
So there you go. He's going to abandon the motion Sarah Boone filed. No surprise there. And he is going to substitute in a couple other motions. And basically he's saying the motion for a neuropsychologist, he's substituting out, but for a forensic psychologist, he's substituting it in. So it's asking for the same thing, but he thinks this expert would be better. And you're going to hear he's actually going to bring in an expert that was already on the case, has already met with Sarah Boone, and from my perspective shows that that's good for the judge if he wants this case to keep moving and wants this case to go to trial.
Dr. Julie Harper, who was on this case previously, I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, I hope that she's going to be of that opinion. In addition,
So there's our indication of what this defense is going to be. A lot of people have asked, what is this defense going to be? And he said he believes, and the experts he's spoken to believe, that Sarah Boone does meet the criteria for battered spouse syndrome and battered spouse defense. He's going to talk more about it, but it's very clear that's the angle they're going on. Not he did this to himself, he did it on purpose, I just went to sleep or I passed out, but that in fact, she knew what she was doing, leaving him in there, but was so scared of what he was going to do if she let him out that she decided to leave him in there, not call the cops, not leave the house, not go get a neighbor, not go get help, not call her ex-husband, but just leave him in there and go to sleep. Very interesting.
I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berglund.
Crime scene reconstructionist, accident reconstructionist, and crime scene investigator. That's going to be interesting. I assume, I don't know, maybe to prove she can't put him in the suitcase unless he voluntarily went in. Maybe it did fall, maybe the bag did fall down the stairs, didn't fall down the stairs. What are they going to point out in the crime scene? We don't really know. There hasn't been a lot of discussion about that at this point. All we've seen about the crime scene is the cell phone videos.
It was from my area, Pensacola. Is who I am recommending to be appointed.
What was his name again? I'm sorry.
Michael Berglund. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I put them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the comments number 2. I have not yet seen these motions.
So another motion that he's filed is a statement of particulars. That motion has already come through. I don't think we'll have time to fully break it down today, so I'll probably do a recorded video to post later breaking down that actual full motion. But generally speaking, a statement of particulars is more specific information about the arrest and the crime, date, time, and place, things like that. That is not specific enough in the charging document. But to break it down further, I'll need to read through the motion some. So we'll probably have to do that in another video because I really want to watch this entire hearing together.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
And then yet another motion for additional discovery. And what I want you guys to think about is, would Sarah Boone have been able to do this on her own? Just an example, right? She asked for maybe the wrong type of expert. He's got the right type. The one that was already on the case, she might have looked for a different one, but he knows as a lawyer why it's better and more beneficial to use the one that was already on the case. He wants a statement of particulars because maybe he's setting up a defense that he needs more specific information on that they didn't give him in the charging document. He's going to have an accident reconstructionist or crime scene expert come and testify about some stuff. There's other discovery, and he's going to mention what it is that they need, and he's trying to force the state to give it to him. And he's going to present other issues that have popped up in the case. There's no way Sarah Boone would have been able to do this on her own. But it's also interesting that none of the other lawyers did these specific things. Some of them had these experts. Some of them were going to go with battered spouse syndrome, but not necessarily a statement of particulars or additional discovery. So it is interesting to me about where this goes. How long is this relationship on the ups? That's something I'm wondering. Will this last?
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't. They're all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report.
So JAC is not here at this hearing, so they're not really going to be able to tell what's going to be approved or not approved when it comes to money without JAC. But they've already approved, I think, that expert, or at least funds for that expert. Maybe he needs more. Maybe he thinks there needs to be more meetings. But to me, it's moving in the right direction that if it's an expert that's already been on the case, JAC kind of already approved it or indicated they would approve it. It's more likely they'll approve it this time. So we can get moving, get this expert, get the testimony, let her meet with everybody. She's already met with Sarah Boone a couple times. I believe it's a she. I'm not positive. So that's all good news as far as pushing towards the October trial date.
They were sent to all persons on service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week. but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday, and I've spoken with Dr. Brooklyn 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Brooklyn. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So,
Autopsy photos and crime scene photos, they can't find. That's a problem. All that's had to be turned over. My guess is it is somewhere. They just can't find it, whatever it may be. And the situation they're in now, the state maybe can point them to where those photos are, where those documents are, where those reports are, so that we can keep moving forward in the case. Jennifer said, I'm so confused. Thought the judge made her represent herself, wasting the court's time with so many attorneys. How was she allowed to have an attorney again? So no, the court cannot remove your ability to have a lawyer. What they did was remove her ability to have a court-appointed and state-paid-for lawyer because she kept getting in fights and saying she didn't like them and blah, blah, blah. But when it's a private lawyer, that's a relationship that both sides enter into willingly. And as long as she has that and is not going to complain about that, but she's also going to find out here, you get rid of Owens, that's not going to create a continuance for you either. And that's really, I think, what the judge ended up being worried about at the end of the day was all the delays, all the fights, and how she acted and treated those lawyers that were paid for by the state. That's what was removed. He wasn't forcing her to necessarily represent herself, but removing court-appointed, state-paid-for lawyers. Chris K., what did Mr. Owen mean when he said filed his list of particulars? So he's requesting that list of particulars from the state. And again, Chris, there'll be more on this in another video.
I know time's of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs provided to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already.
Yeah, and that's no surprise. They have it all. They can't find it. We'll help them find it.
When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to.
So they sent him a different set of discovery than was sent from the client. So you can also understand how annoying this is for the state. Listen, it's their job. They got to do it. We got to protect criminal defendants' rights, but they've provided it to lawyers. They've provided it to the defendant. Now they're providing another copy to the lawyer. And it's just, you can see how annoying this process can be. And I'm sure nobody's really excited about it.
As well, that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB, and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state of the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
Go ahead.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to...
He denied that because Owen said, we're going to pull that off. Michelle said, if you're declared broke or indigent, as we call it, she can go on and pay for her own lawyer sometimes, or somebody can pay for her. there can be some kind of crowdfunding, or the lawyer can do it pro bono. I don't know, maybe he wants the recognition or publicity, or maybe somebody else is paying, or he's got some kind of deal with her where she's paying a nominal amount monthly. That's between the lawyer and the client. She can no longer fire an attorney, or the attorney quit, correct? So she can still fire the attorney, and the attorney can still quit if the judge allows him to withdraw, of course, and allows that relationship to be broken, but it's not going to create a continuance. The judge is not going to allow her to, on the eve of trial, fire this attorney and say, okay, now I need more time to prep myself. He is really setting it up to not have that happen. John, did Sarah Boone have any signs of bruising when the police arrived? I don't remember any personally, but I didn't see any photographs taken at the police station. I don't know if she was claiming any kind of self-defense at the time. It certainly didn't seem like that based on her interview or interrogation. So we'll see.
The motion to appoint crime scene reconstructionist and death investigator, and motion to appoint forensic psychologist. State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Berrios, I'll ask the clerk to see if we can push these through the portal today, so that Ms. Berrios can reach out to JCS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone on manufacturing defense. And there's a second
I want to make sure there's not an issue on Sarah Boone manufacturing a defense. That means coming up with it later, making it up because it's the only thing that might fit. You can't accuse her of that. He's going to try to block some things like that.
Dr. Michael Brandon. Dr. Michael Brandon?
B-R-A-N-N-E-N?
Dr. Michael Brennan, I saw somebody say earlier that Brennan came on Court TV and said she doesn't fit the battered spouse syndrome defense. Is that the same Dr. Brennan he's talking about here? I don't know.
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year.
He's talking about some expert that testified in a different case where it was a first-degree M case with a shooting. He testified to battered spouse and ended up in an acquittal. So obviously that's a good witness. Sounds like he wants to try to use them in Sarah Boone's case.
It was a 2019 case, and that took a while to get to trial. But Dr. Brandon testified that battered woman's experiences affect her perception of imminent danger. And that's going to be a question.
A battered woman, and remember, this is going to be important. This is the type of stuff they're going to try to testify to. A battered woman's experiences may affect her perception of imminent danger. We're going to listen to him say it one more time because I think it's really important. This is what this case is going to boil down to. Did all of her past experiences with George make her feel like she was in fear for her life at that time? All sorts of things will be relevant, like her DV against George, like her actions and her words and how she was acting, that she seemed scared in those videos.
2019 case, and that took a while to get to trial. But Dr. Brandon testified that battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone at the time of her actions was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not. Yeah. I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to.
So he's tried to reach out to Brandon. He has not hired Brandon. Brandon has not met with Sarah Boone. It doesn't sound like Brandon's payment has not been approved. But these are some of the things Owen's trying to do. Again, one of the reasons he's asking for a continuance, and probably something he's going to ask for more money for. All of that stuff takes time.
Reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be. That's the only other witness I'm going to.
Website says he responds within 48 hours.
That's one forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Harper. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic.
So they need an investigator to go out, interview people at the apartment complex to prove, who was the aggressor, all the prior domestic violence issues. Corin said, don't most women who win with battered wife defense have a history of severe injury and end the life with a knife or gun or immediate fear for their life? How can she win after watching him suffocate for hours? So I will say, Corin, you bring up a great point that this is a unique set of circumstances. Not one like I've seen in any other case, but I will say there is room in a battered spouse defense that that your spouse reacts a certain way when something goes wrong, whether you make fun of them, whether you laugh at them, they're in the suitcase, you don't do what you're told immediately, they fly off the handle and end up abusing you. There's a lot of different stories I've heard and clients I've spoken to and experts that explain a lot of things can go into this, right? It's not just he hits me with his fists or he, threatens me with a weapon and then I respond one day with a weapon. It's not always that cut and dry. Every relationship and situation is a little bit different. So I think there's room for that, but there's a lot of context in this case that A, we don't know, like some of the past, and B, that to me doesn't really fully seem like she's a victim of DV with how she sounds in the video and acts afterwards, right? And she doesn't say anything like that when she speaks to the police afterwards immediately or in the interrogation room. And like the good doctor brought up, she said everything was fine. We were playing puzzles. Dorothy, why is it easier for the PD to quit than private attorney? It's not really. Sometimes, like you're going to hear the judge say later, which is exactly what I expected the judge to say. Hey, Mr. Owens, guess what? You chose to take this case, sir. You knew the time requirements. You knew the case. You knew the client. You knew the issues, and you still signed on. So sometimes that's held against private attorneys a little bit more than public defenders. But generally speaking, if we have a conflict of interest or irreconcilable differences or an ethical issue or we just can't represent them anymore, usually the judge will let us off, but they're not going to let us off if it's going to screw the defendant. If you're going to violate the defendant's right to a fair trial and right to effective assistance of counsel. So the judge is going to say, you do everything you can to represent this client the best you can. And maybe it'll turn out being like Robert Tellis, where, he does a narrative because they can't ask her any questions. They're too afraid of, eliciting a lie on the stand. I don't know if we're going to get there, but that's why things like that develop sometimes in cases. Azam, Peter, in a case, he resigns or is fired after the trial starts. Do you think the judge would let Sarah continue trial as pro se? Thanks. 421,000 subscribers. Yes, it's crazy. You guys are the best. Keep subscribing or keep working to 500,000. I think we're going to do some kind of party at 500,000 if we ever get there. But yeah, I think the judge will advise Sarah Boone either he's not going to let this guy quit in the middle of trial, or if he does, yes, Sarah Boone will have to represent herself. That's pretty prejudicial to a client if your lawyer walks out on you in the middle of trial and you've got to do it yourself now. To do all that in front of a jury is pretty problematic. Joanne, I want to thank you all because I was in the fight for my life, and it is this channel and community that really sustained me while in treatments. You're all the first to know that I am officially cancer-free. Well, that's amazing, Joanne. Thank you so much for sharing it with us. Thank you for being here always. So pumped that you're here, and to the chat that makes this an enjoyable and educational experience for everybody. Thank you guys. Keep it up. And remember that when even it's hard to be respectful to people that disagree with you, it's hard to be respectful sometimes when you really hate another person's opinion, not the person, but the opinion. This is why we keep it respectful. We like to disagree amicably and try to learn from each other because it really can mean a lot to a lot of people in the chat and to me. So thank you guys so much. And thank you, Joanne. All right, let's keep listening.
Trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney director, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs.
I have been retained, so I'm not going to make any claims for attorney's fees or travel costs. And remember, he was the elected public defender in the area in which he practice, I think, around the Panhandle. But all of these things are indicating that somebody's paying him. Maybe it's Sarah Boone, maybe it's not. But you can still be considered indigent as it comes with costs, because they're still asking for costs for experts and for investigators and things like that.
Just for these weeks.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was in one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs. They've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone. Thank you. All right.
So because she was pro se, because it used to be the public defender, because JACS approved it like that, sometimes logistically, procedurally, you need to change stuff up when you have a lawyer. Not going to be a big deal, not going to affect her ability to get this funding.
That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Roberts.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. But it is critical to my theory, our theory of defense, status spouse syndrome. As you know, that takes time to develop.
He mentions, just like he did in his motion, abuse of discretion when it comes to continuing cases, because it's pretty much up to the judge. But if you abuse your discretion, judge, you're making a major mistake here, because we have to do this battered spouse stuff.
Especially with the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. It involves some extensive history. Obviously, that couple was together.
So what he's saying is, I can't do all this so quickly. Sure, I could draft a motion and file it, but I've got to have the corroborating documentation. I've got to talk to experts. They've got to make this happen. And as we sit here, it hasn't happened.
For 3 or 4 years, I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torrance in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate.
So, Kelsey, can you see if you can find this video of the interview with Owens after the hearing and text it in our chat so I can take a look at it next, maybe, depending on how long it is?
Make their opinion as to whether she is, in fact, that spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her later yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not involved. I believe you were involved at that time for Mayor David.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim to. And I would respectfully ask, I'm not asking for, I think most times you put on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that would be.
He's so smart too. Like that is the way to ask for it. You don't ask for a year. You don't ask for 6 months. 1 trial cycle could mean 1 month, just near the end of the year, Judge, just November or December. That's smart. And that's, I think, all the judge would ever consider. So I think that's a smart ask by this lawyer, and that's telling. Corin said she's never admitted to killing him intentionally or shown any remorse, much less that she feared him and claimed only it was not intentional. No, yep, that's certainly what it sounded like. I think she's got an issue here with a lot of her prior statements, but he's going to mention later also a brand new detail we have not heard any lawyer or Sarah Boone say. And that is, he thinks he's going to get all or part of her interrogation and interview thrown out. So there's going to be some motions in limine or motions to suppress coming.
We have enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Padilla has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's files.
And then, like any lawyer, one trial cycle just near the end of the year, maybe 2 or 3 months, maybe 3 or 4 or 5, maybe 6 months, Judge, right? Wants as much time as he can get to prepare all this, but the judge ain't going to buy it. So he's got to know that.
She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. They haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, they'll be ready.
Yeah, I mean, there's a million issues, Josh and Sloan. It's like she went upstairs to go to bed. She didn't say, I was so afraid that I ran away. So they're going to have to be able to like show, maybe not, she didn't even say it in the moment, but this is why she was feeling that way because of everything that happened, because there are all these issues from the past. That's what I can gather.
If you're trying on October 7th, I believe I could, but not without better spouse certificates because I don't believe.
Do I think I could try it on October 7th? I think I could. That's basically nailing the first nail in your coffin. You might as well say, I just don't see, like Ann Taylor does. Judge, I just don't see how it's possible. The judge forces you, you do it. But let's hear him say that again. I think I could, but not without the battered spouse, which means if you're the judge, if you can get all the battered spouse stuff done and let him do it for trial, he's ready to go October 7th.
File some motions relating to that. So because of that, but ultimately because, yes, they'll be ready for trial on October 7th. I believe I could, but not without better spouse certificates because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys. And in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case.
That's good too. The state's already hired their counter expert. So all of this stuff could be very, could move quickly.
In anticipation of potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose any continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week, the time is expired. If the judge doesn't continue today, he wants to have a conference next week, but it's too late for him.
What's your
Because it has to be, you have to give the notice with the corroborating details, meaning expert says X, Y, and Z. She has battered spouse syndrome. That's going to be our defense 30 days before trial. They can't wait till next week to do that. And again, I respect the argument. I respect the game by the lawyer, but deadlines were made to be pushed. And this deadline can be extended or continued like any other deadline by agreement of the parties, and as long as the judge allows it. So the judge right now in his head is probably thinking, they already know their expert. State already knows their expert. They've already met with Sarah Boone. Extend the date a week or two. Let it be 15 days before trial. The state already knows it's coming. The state doesn't object to it. Give them battered spouse, but let's push this trial to October 7th.
response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to get it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist that makes that claim. I just can't say, hey, I'm going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No.
All right, thank you very much. All right, Mr. Earls, it seems like you've already started diving.
So before we get to the judge's ruling, let's answer a couple questions here. Olga said, "Hi, Peter. I thought Sarah was representing herself. What changed? I thought her attorney already quit. Has this already been explained in your previous videos? If so, I'll check out those videos." So yes, the video I did Friday breaks this down fully. The quick explanation is this attorney responded to her wanted ad literally and now is a privately retained attorney. The court said he was not going to appoint any other lawyers, so she'd have to represent herself if she can't find her own attorney to pay. She chose option B. She was representing herself for a minute. Know anything about Owen's backstory, John? All I know is in last week's video, the one I did Friday. That's all I really know, which is why we found, or which is what we broke down on that video. Do you see any arguments that would get the police interviews thrown out? So far, no. So far, no. She couldn't have been happier to speak to the police and prove her innocence, and she thought she was going home. I didn't see any major issues as I watched them through. Maybe certain things here and there you can keep out, but generally speaking, I think most of the bad stuff's coming in. All right, let's get to the judge's ruling here.
The case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
So that's the first little slap is you've reviewed this case. You've spent time on this case. Clearly you know what's going on. And like I said in last week's video, when judges start that way, they're like, hey, brother, you knew what you signed up for. Nobody forced you to do this.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions.
It's like, you know this. You know the bad behavior. You know what I was dealing with. You know how we got here. This is not your average case.
This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what you were identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and it would not continue for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed.
A smart lawyer slash judge can predict the future, right? We're not fortune tellers. We don't know what's going to happen in the future, but we know the probability and what's likely to happen. And Kranick looked into the future and said, she may hire a lawyer. I'm not going to give her that opportunity to use it to continue the case. Now, I will just tell you myself, even though that happens, even though judges say they're not going to continue it, so often they do. Is this going to be one of those situations? It surely sounds like Kranick's going to say no. He's building up to, I already said no. I already said no continuances. I already said extraordinary circumstances. And I already said this hiring a private lawyer is not an extraordinary circumstance. Yes, the smile is gone at this point.
In this case, when you undertook this assignment knowing that you were not being appointed and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the...
Wait a second. I think he just said you took it pro bono. So he said you chose to take this case. Let me see if he said pro bono.
You undertook this assignment knowing that you were not being appointed and that by your own representation, you're doing this free of charge on a pro bono basis.
By your own representation, you're doing this free of charge pro bono. I missed that the first time I listened to this hearing on 2x speed. So there's your answer. He's doing it pro bono free of charge, but that's his own admission. Again, the judge can't force him to say that. Now, if he wants to use it to try to get those JAC funds and try to prove she is indigent, judge, she's not paying me $1 million and then getting the state to pay for her experts. So he can use that in his argument to try to get funds to pay for experts and private investigators and things like that. I will also tell you, remind me if I forget, to tell you how him being pro bono affects his response to the judge's ruling here.
Not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz on Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Margo v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern 3rd 1277 and pinpoint 1281 by the 4th DCA in 2011, citing to Watson v. State 84 Southern 2nd 540, also by the 4th DCA in 2004. In that case, defendant Ronos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ronos...
Still longer than this, but he's laying the foundation, laying the record, CYA as you call it, as to why he's not going to grant this continuance. He is going to deny it. He's saying you got plenty of time. You knew what you were getting into. Experts are already in order. We can move this stuff along. We can continue certain things. I can't respond to certain motions that you just filed that I haven't had a chance to look at. But the judge is denying this continuance, which you may not understand how unusual it is in this situation for the judge to do it, but it is unusual.
Ramos' previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued.
Basically, it's Boone's fault you have such a short time and short notice of preparing for trial.
16 times. As of the date of your filing your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th. And the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out. Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations at various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you were not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986. With the duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012, you've tried over 100.
So now he's going to say, this is when your reputation and your competence is held against you as a lawyer. He's like, sir, you're very experienced. You know what you're doing. You were the elected public defender. We went through this guy's entire resume and his website, just like the judge is going to do on our last video. The judge decided to put all this on the record. 100 jury trials. Been a lawyer since 1986. That's 37 years. This guy was the elected public defender, very experienced criminal defense attorney. He can handle it. This isn't some noob. This isn't his first rodeo. And again, that's basically being held against him, being like, yeah, you can do it.
Cases first throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with.
Meaning you may have filed your notice of appearance on August 30th, but you've already met with her 4 times, including yesterday. You're up to speed. You're catching up. You're working the case. And again, this is one of those where it's like, damned if you do, damned if you don't. It's like if he wouldn't have done anything, it's like, why didn't you do anything? If he does do stuff, it's like, well, you've already done all this stuff, so you can try the case.
Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms
It's like, yeah, you got plenty of time. He's got like 3 days to file that. It's tough. I think they should extend all those deadlines. There's no way. I'll just tell you, I will have to, I will not be happy if they don't allow them to claim battered spouse syndrome because of a timing deadline, because it happens after 30 days prior to trial. There's just no way they can strike that. He's got to have more time to allow the experts to come in to talk to them. Even if they don't push the trial date, they've got to push that deadline. We've seen them push deadlines for much more in much less, serious cases. So there's just no way he can be held to that and say, well, too bad. You knew what you were getting into. That just can't happen. So they've got to let them do the battered spouse investigation and notice.
State 311 3rd 185 10.189 42nd BC of 2020. Your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pre-trial. The pre-trial is matter of trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, now, I have a full practice. I've got a docket day this afternoon in Santa Rosa County, full circuit Judge Scott Duncan. Got 12 clients. Okay, I've got to be covered. I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Thank you, Judge.
No, Your Honor.
The only request I would have, sir, is the
Totally reasonable to appear by Zoom. He's from out of town. He's got a full practice. He said, totally appropriate. If you would have said no to that, a lot of people are thinking this judge is now like has some vendetta against Sarah Boone. I really don't believe that. I think he's trying to do the right thing and bring justice. You got to remember, there's a victim and victim's family. There's witnesses. There's all sorts of people involved in this case that are not Sarah Boone. Her rights are very important. We got to make sure she gets a fair trial, but you can't just delay the inevitable forever. We have to get to this trial. That's what the inevitable is, not whatever the verdict ends up being. And so he could have been like, because I've had judges say, no, you got to be here in person, and it does not make me happy. There are certain names and words for judges that are not appropriate to share here that I have for judges that do that for no reason, especially with today's technology and how easy it is with Zoom. This judge has absolutely no problem. Says, sure, you can appear by Zoom, which actually allows him to do this case, because if not, he probably literally physically couldn't do it.
The rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it, and you can appear virtually. There's no reason for you to drive all the way down to Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, there are no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce a trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct. So the deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're originals, but I'm going to need to look at that. And I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I did get done a lot of the things that I wanted to get done within that period of time. Probably would have taken a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to do it.
Some of it is a problem to be presented before the jury. So we're going to dig into those videos at some point with this lawyer and see which parts he wants redacted, cut out, suppressed, eliminated out, whatever you want to call it. We're going to see what what he has problems with from that interview.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defense investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with the station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's orders. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Meaning reviewing the digital evidence, he's saying Boone didn't do it, supposed to be done by today. Seems like they could have still done it today. He wants to continue it so he can be there as well.
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison-based break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9.
Regardless of what's been viewed, digital evidence, digital exhibits, physical evidence, physical exhibits by Sarah Boone, with Sarah Boone, however you want to say it, this lawyer's got to go through it all. And whatever the state wants to put in, whatever exhibits, whatever witnesses, this lawyer's going to have the opportunity to object, to argue that it shouldn't come in, should come in, whatever it may be, provide his own witness and exhibit list. My guess is the judge will extend basically every deadline that is possibly, fair enough for the state to be able to respond and prepare for trial in order to get this trial to go October 7th. And I still would say there's a 5% chance it gets continued. I still would not say it's a 100% chance it goes October 7th.
Paragraph 6, prison break investigation shall file with court a notice reflecting the discovery in the USB jump drive, which contains the state digital evidence was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, per the case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state.
No.
Okay. How much time would you like,
There you
sir?
go. I mean, just expect all of those deadlines to get extended as up to the week before trial, basically, which frankly is not that unusual for trials. Just kind of like Ha H said, trials had 16 continuance. That's not that unusual, especially in criminal cases that have a lot of continuances, especially if the defense asks for them, they're normally granted, which the defense has asked for plenty in this case.
In order to review the state's digital evidence that it seeks to admit into evidence and tender any objections.
I've got to go buy jump drive. I've got to take it down to his office. He's going to give me the evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State.
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Terry Jones?
Give me 1 minute.
Sure.
That's it.
State, anything else?
Not this time, Your Honor.
Madam Clerk, going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close business September 10th to file responses to motion for statement of particulars and motion for additional discovery. First time no business before the court. You'll have the fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
So before we get to the lawyer's word with Sarah Boone at the end, which I know a lot of people have sent me about and we're going to talk about, let me answer a couple questions and make a couple comments. Do you think the denial of the continuance could boost her potential appeal? So I'm not going to say she's going to win an appeal over it, but it's definitely an appellate issue that they're going to deal with. Doesn't mean she's going to win over it, but that's one of the reasons I would have continued it a month or maybe 2 months before the end of this year, just to kind of eliminate that appellate issue. This judge didn't. He's very confident in his research and laying the record for it. Mila Earl, Peter, do you think Sarah is listening to attorney and realizing what he's doing for her? I hope so. I hope so, especially if he's doing it pro bono or somebody else is paying. It's like you have no control. Appreciate what's being done for you. Corin, do you know anything about the prosecutor? I do not. Never heard of him. Never met him. One of my buddies from law school on my mock trial team was a prosecutor in another high-profile case, kind of similar to this a couple of years back. We haven't heard much from him so far. I'm not overly impressed. P.S. My shady ex-landlord is about to go down in flames in small claims again. Will you try to attend some of this trial, Lynn? As said earlier, as a maybe, yes. So I do have a retrial from a case that ended in a mistrial for me because the jury panel busted, not because of a hung jury. I think it's November, though, not October. Hopefully it's November and I'll be able to go. If it's in October, I'll do my best, but I think I'll be able to go, yes. Peter, the attorney statements after court are on Fox 35 Orlando website. I was unable to include the links here. Thank you so much, the Pilgrim Shadow, for that. I see Justin saying he said that Sarah agreed to pay him. Other people said he's getting funds from a lady in Minnesota. Here's what I'm going to say. Hit that like button if you haven't already. We're already over an hour now, so I don't have time to break it down today. More motions are coming in from this lawyer, including a bill of particulars. We're going to take a look at those motions and that video. I don't know when. Maybe we'll do it tomorrow live instead of a pre-recorded video, which I was planning. We'll do it tomorrow live if you guys get this video to 10,000 likes. So everybody hit that like button. If we get 10,000 likes, we'll do another live on Sarah Boone tomorrow because there's so much happening in this case. Deb said, I wonder if the judge is still going to leave 3 weeks for the trial. We'll see. Now that there's a defense lawyer on board, he can tell the judge how long he thinks it's going to go. Sarah Boone obviously has no reference point. She doesn't know. We always extend, like I say, if it's going to be pro se, but maybe it'll only be a week or two now. Jury selection will be longer with a defense attorney than pro se because they know how to do it and they need to do it well and take time with all the media attention in this case. But the rest of the trial should take less time with an attorney than Sarah Boone. I don't think 2 to 3 weeks is overly long if there's going to be an expert intensive battered spouse syndrome defense. You heard him, 2 or 3 experts. The state's going to have 2 or 3 experts in rebuttal. So, I don't see how this goes less than 2 weeks. He can't use Zoom for the actual trial though, right? No, Reese's mom. No, not Zoom for the actual trial. Just all these hearings and motions and things that are going to happen coming up to trial. John, you mentioned a possible party for 500K subscribers. I haven't heard anything in the video since. Kidding, but do it. Yeah, we'll see what that looks like. I've heard some different iterations of it, but we'll see how we can include the subscribers and members and stuff and something that we do, but Whitney wants to celebrate it. So that'll be fun if we get there. So, okay. So before we go, let's watch their interaction here at the end of court and see the fist pump. And a bunch of people were telling me, I'm going to slow it down to normal speed. I just had it barely boosted, that he passed her a note and what's going on. It could be drugs. Somebody literally said to me. So let's take a look at this here. Now, you guys tell me what you saw. All I saw was a fist pump. I'm going to back it up. We're going to watch it again. A bunch of people are saying he passed something. Number 1, your lawyer is allowed to pass you notes. Number 2, your lawyer is allowed to give you things in jail nobody else can look at, legal mail. Number 3, your lawyer is a complete moron if he puts his bar license on the line, his livelihood on the line to pass you drugs and commit a crime while representing you. Very unlikely. It does happen. It has happened. There are stupid lawyers. But she's not just bringing whatever she wants back and forth. She gets checked multiple times. There's multiple times between here and her cell that she'll get checked. She can't just take anything in and out. But your lawyer can give you things whenever they want. Basically, they can send it in the mail. They can bring it to you when they meet. There are all sorts of different requirements, but lawyers also know what you can't bring in the jail. He's not going to give her drugs, obviously. He's not going to give her a knife or even a sharp item like a pen or something like that. He's not going to do something like that. If he passed her a note, he's allowed to, and the bailiff can't read it. It's legal mail, things like that, but it can't be anything dangerous, et cetera, et cetera. But again, when I watched this, it purely looked like a fist bump to me. You guys tell me if you see something different. We're going to watch it again. Holds out his fist. She pulls her fist up in her cuffed fists and fist bump. Now, maybe he walks over again. See, taking the pen away. Let's see if he comes back over. Yeah, she said, thank you. She says bye to somebody in the gallery. And that's it. And that's all she wrote for that hearing. Okay. So a bunch of people are saying, I think it's a note. So I don't know. Maybe he did. Def gave her something. People are saying, okay, maybe I just didn't see it. That's funny. It just looked like a fist bump to me, but that's okay. And again, he's allowed to pass her a note. That's okay. And it's an open court. The cameras are on. He would be a complete moron if he passed her some contraband or something illegal like that. But you guys let me know if you want another live, or if I can just pre-record it, whatever, if it's not that important. But there's multiple motions, I think, coming. At least one's already been filed and uploaded to the docket that I've seen. That interview, we have a link of the interview where her lawyer speaks after this hearing. So again, that can be tomorrow's live. If it's something you guys are interested in, let me know in the comments, and make sure you hit that like button so we can get this to 10,000 likes. You guys are the best. I appreciate it. This case is coming fast and furious with no continuance. We've got a month till trial, folks. And I'll be in Orlando to check it out at least one of the days, maybe multiple days. So I appreciate you guys so much. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.